Protecting innovation. Firms should protect their innovations. There are many reasons for firms to try to protect, to defend what they identify, what they promoted, what they created as a new innovation. And this is also a way to give an appropriate compensation to the firm, to the employees, to the stakeholders, and the owners, and so on, of all the hard work, all the technologies that have been created by the company. But at the same time, it's not always the case that protected innovation should be the post star for firms. So there are also reasons to at least decrease the protection of innovation. And this, to an extent, might sound weird in the first place, but if we reflect more, we understand the reasons why it's important to identify a balance when it comes to the protection of innovation. What should firms do? Well, first of all, they should create a portfolio, and in this portfolio, list, map, identify all the innovations, all the technologies that they have created. We should also list what technologies deserve protection and what technologies do not deserve protection. And this can also be for purely business reasons. We know that in some cases, having a more liberal approach make your innovation more accessible to other companies that can provide complementary goods. This will help the diffusion of innovation. This is a key concept in innovation management, which is the S-curve of a diffusion of innovation. And so if this is the case, if these are the circumstances, so we may deem to reduce the level of protection of our innovations. But at the same time, in some cases, the innovations that we created don't have a very impactful commercial application. So in that case, keep defending, keep protecting these intellectual properties may just be a waste of resources for the organization. And additionally, in some cases, we may even prefer to license these technologies. So rather than just protect them and keep them internally in our organization, we may want to extract value out of these technologies, especially in the case we don't consider these technologies to be crucial for our core business. And so some other companies can exploit them, and for us, we can get profits out of this, like a royalty fee that we can earn from a license agreement, for example. Or we may want to enter a new market. However, we don't want to do this with our company, with our brand, but just to appoint, to assign someone that is already operating in the market and giving them license to the technology and let them commercially exploit our technology, and from our side we will receive the fees from royalties. So as you can see, this is a very complex topic, and it does require a lot of analysis before understanding what is the most appropriate way, what is the most appropriate balance between innovation protection and accessibility to innovation. So we can consider first some thought-provoking brainstorming questions. So first of all, we need to understand, we need to know, we need to learn what are the key tools in intellectual property that are primarily patents, copyrights, and trademarks. What are they? What are the differences when we can use a patent? When can we use a copyright? When can we use a trademark? And other example, let's imagine a firm that would like to market an innovation in multiple countries. how many factors should we consider to protect the innovation, or in some cases to open the innovation for commercial exploitation through licensing agreements? Or how can we protect this innovation in multiple markets? Or also, when we can't use patents or copyright or trademarks, how can we protect the trade secrets of our organization? And in case there is no legal protection that we can use, is there any situation where we actually do not need a legal protection, or even we don't want to seek a legal protection for our innovations? So all these topics, all these initial food for thoughts will be explored in the video lecture today. So without further ado, let's now move to the main content for today's lecture. Intellectual property rights and innovation management. So the first step here is to understand whether companies would like to protect their innovation and how they would like to protect their innovation. And there are reasons for both. So there are reasons for companies to really implement a very strict protection system of their innovations, but at the same time, companies may decide not to protect vigorously their innovations, and this is because they would like to increase the install base of their innovation. They would like to, especially in the case of products where network effects apply. So in this case, they would like more people to be able to use this innovation, because consequently the value of innovation will increase. So in this case, the firm may decide not to go for a strict protection of innovation, but to be to an extent more flexible and to allow to some extent other companies providing complementary goods to use the technology of a new innovation. A fundamental concept that we need to address first is the idea of appropriability. So appropriability is essentially the degree, the ability of a company to capture rent out of innovation. So we know that a rent is essentially that position that a firm is able to gain by developing new innovations. Rent, because similarly to real estate, if you are a landlord, then you have this privileged position that will allow you to receive rents from tenants. And the same similar type of concept applies if you are an innovator. And if you are an innovator that protect the innovation through, for example, through patents. So by protecting the innovation, so you can exploit all by yourself that innovation for a period of time, and the length of your intellectual property right, the size of the market. So this will basically determine your rent position. So how can we identify this concept of appropriability? So essentially, appropriability is determined by how easily and how quickly competitors can copy your innovation. And this generally happens when an innovation is codified, when an innovation is put in writing, when an innovation is documented, because then it will be feasible for your competitors to catch up and to copy your innovation. But there are some type of innovations that are very difficult, very challenging to copy. So these are generally innovations that consist of these two main features. So they are made of tacit knowledge. So a tacit knowledge is basically knowledge that can't be easily codified or documented. And this innovation come out of a social complex knowledge. So social complex knowledge means essentially the knowledge that comes out of the interaction among individuals. To give you an example, think of a lab, like a research lab, with scientists working together as a team in the research lab. So the interaction among the scientists, what they communicate, the teamwork, all of this would be an example of a socially complex knowledge. And as you can see, this is not codified, this is not documented, there is no manual about this kind of interaction. So if you have these teams in your organization, high-performing, high-skilled scientists in your organization, then it will be more difficult for your competitors to copy your innovations because they need to copy people, they need to copy the behavior of people. And even if they poach and hire some of your talents, but it doesn't mean that then these talents in a different context will be able to create the same innovations. So we have this very peculiar mechanism of social interaction among individuals that is very difficult to replicate. So even if you hire some of these people, it doesn't mean that you are transferring the knowledge completely. So maybe you will get some knowledge, but not completely, because you are also missing out all these interaction, cooperation, teamwork, and so on. However, this is not always the case. So it's not always the case that we have innovations based on tacit knowledge or socially complex interactions. So generally, there are other remedies for companies to defend their innovations. And these are generally legal measures, and primarily patents, copyright, trademarks, and finally trade secrets. So let's move on now and let's examine what patents are. So patents are basically a right. It's a right to a monopoly given by the government. So this right is given to inventors, and the right will exclude other companies to produce, use, or selling this invention. However, there are different types of patents, and there are also different requirements, different criteria to create an innovation that can be granted a patent. So first of all, different type of patents. So we have utility patents. So these are patents for processes, machines, equipment, and so on. Design patents. These are patents protecting a design of manufactured items. And then we have plant patents. So this is to protect different type of plants. What are the criteria to be granted a patent? So first criteria is that the invention must be useful. What does that mean? It means that the invention must produce a desirable result. For example, must solve a problem in the marketplace. Second criteria, the invention must be novel. Of course, should be something that is not already patented or is not described publicly or of public domain. And third criteria, must not be obvious. And here the standard is based on the normal skill set of a person employed in that industry. So what we say here is that a person, normal person with a standard skill set in that specific industry of a patent. So let's imagine a patent for a drug, medical drug. So it will be a person employed in the pharmaceutical industry could not come up with that invention. So if it's something that everyone in the industry could have invented, so then in this case, this invention does not deserve a patent. There are also some further exclusion to patentability. So one is a scientific discovery. So we generally say scientific discovery is something that always existed. So you just discovered it. So scientific principles are just discovered, so they don't deserve to be patented. And then in case you just like substitute some materials, or you change the size, or you make something more portable or more usable and so on. So these are like literally minor changes. And again, these minor changes do not deserve to be patented. A turning point in patent history was a decision by the Supreme Court of the United States in 1998, which allowed software algorithm to be eligible for patent protection. So before 1998, there was no patent protection for algorithm. So algorithm could only be protected via copyright. So the process to apply for a patent, it takes some time. So it depends on the country. Each country does have its own patent process, red tape and so on. In the US, we take between 3 to 5 years. In other countries, we go up to 6-7 years in total to get a patent. And the process is also, of course, it also includes fees. So in the US, the filing fees for a patent are around $1,500 plus around $10,000 of legal fees at a minimum. So, of course, there are also these legal costs to consider when patenting a new innovation. An additional challenge is that there is no standard globally, so there is no global patent. So each country does have its own patent system, patent application process, and patent protection. Which means that if you want to protect your innovation in many countries, you need to go through this patent process in all the countries you would like your innovation to be protected. However, there are a couple of treaties, the Paris Convention for the Protection of Industrial Property and the Patent Cooperation Treaty, or PCT, that harmonize the legislation about patents. So what are the key concepts of the Paris Convention for the protection of industrial property? So even though we are not yet at the stage of having a word patent, but here there are a couple of very crucial benefits. So one is that foreign nationals can apply for the same patent rights in all the member countries, and actually the member countries in this treaty are almost 180 countries, which means almost every country is a member of the Paris Convention. So this means that there is no discrimination towards foreigners when we are applying for patent rights. And the other important feature is that the treaty provides this right of priority. So if an inventor has applied for protection in one member country, then this inventor, for a certain period of time, which is 12 months for utility patents and 6 months for design patents and for trademarks. So within this period of time, the inventor can apply for protection in other countries, members of the Paris Convention, and his invention will be treated as the inventor had applied on the same date as the first application. So let's imagine you apply for your invention in France, and then you would like to extend this to Madagascar. So if you apply on the 1st of January in France, and then you apply in Madagascar after 3-4 months, still the protection in Madagascar will date back to the 1st of January, which is when you first apply for this in France. So this is a very important feature of the Paris Convention. Moving to the other treaty, which is the Patent Cooperation Treaty. So also this treaty, the member states are around like 150 member countries. So again, very significant amount of countries. So also this treaty, the PCT, is offering some important benefits. Specifically, an inventor can apply for a patent by going through the PCT office in his country. And then this will give him the right to apply in more than 100 countries, so all the member countries of a PCT treaty, for an additional 2.5 years. So as you can see, here we have a more harmonized system. So because if you apply to the PCT office in your country, then there is more standardization, and then the PCT offices in all the other countries of the member states to the Patent Cooperation Treaty will follow similar rules. Again, this does not mean that there is anything like a word patent. However, it's more likely that if you apply for a patent in a PCT office in a country and then you successfully receive a patent, then the other PCT offices are more likely to guarantee a patent as well, because it has already been granted once. One important disclaimer is that since all countries follow their own rules, so generally countries will say that if you disclose publicly about your innovations, then you are not eligible for patent protection. And this could be a problem, especially if you are in the US, because in the US there is a grace period of 12 months, which means that if you make this disclosure and then you apply for a patent, so if you do this within 12 months, there is a grace period and they will still deem you eligible to apply for patent protection. But this happens only in the US, so this could be a problem. Another consideration when we operate at international level is that there are some regional patent office. So for instance, if you are seeking for a patent protection in the European Union, so there is the European Patent Office, which will basically guarantee a patent which is valid in all the member countries of the European Union. So this, of course, facilitates a patent and intellectual property protection in the European Union. So we've talked a lot about patents and features, benefits of patents. So these are just some figures on patent applications in 2015, 2016. So as you can see, there is a dominant role played by China, United States, Japan, Korea, and then the European Patent Office, which is the Patent Office of the European Union. So this is just to give you an idea of the level of innovation, because one of the usual metrics to evaluate the level of innovation of a country is the number of patents filed and the number of patents which have been recognized in the country. So now we know what a patent is, we know when we should seek this special protection. So let's dig a bit more into different strategies which we can use to take full advantage of patents. So the typical case is that inventors will seek a patent because they want to exploit commercially their innovation. But this is not always the case. So it is often the case that actually inventors don't want to exploit the innovation by themselves, especially if you are like researchers that are more interested in the knowledge and academic challenge of creating new inventions rather than the commercial exploitation. And so then they would like to give to sell the patents or to license the technology to companies that will be better positioned to utilize the technology for commercial purposes. So this is a typical strategy that we see in play when it comes to patents. So inventors selling out or giving out licenses to companies to commercially exploit their new innovations. Another strategy, which is also quite common, and especially in the United States, is the so-called patent trolling. So if you would like to limit your competitors' innovations, or you would like to earn remedies like damages, legal damages through lawsuits, so you can do what is called in a way the patent trolling. So basically you are a target of lawsuits from people that will claim that you infringe patents, and this is just a way for people to get some money out of you. Case in point is Apple. Apple faced and still facing a lot of lawsuits for patent trolling. So for inventors that claim that Apple took advantage of their innovations, and sometimes this is only a way to get some money out of Apple, maybe by reaching a compromise or a settlement out of the court. Another case, and this is especially in the context of software, is when we have this patent thicket. So a patent thicket is basically a dense overlapping of patents. So that's why it's typical of the IT industry, because there are many patents, because in the IT industry we always have some foundational technology and then other technology that have been built on these foundational technologies. And so all the patents are intertwined, are connected to one another. In sometimes it's really difficult to see and to evaluate where a patent finishes and the other one starts. And so this, of course, leads to a lot of potential litigation, because it's impossible to separate these patents. So if some companies own some patents and other companies own other patents, then it's quite likely that will be some litigation. Also here we have a case in point, which is when Nortel went bankrupt. So there were some bids to take over the patent portfolio of Nortel, and the bidder which won this was Rockstar Bidco, that consisted of Microsoft, Apple, BlackBerry, and some other large corporates. And the one that lost the bid was Google. And Google was to an extent very concerned that its competitors, by acquiring these new patents, could then file lawsuits against Google. And so Google then took over some patents from IBM. And then what Google expected actually happened. So there were some lawsuits from Rockstar Bidco versus Google because of like all this bundle of intertwined patents. But since Google took over the patents from IBM, so then Google was able to make a counter-offensive, and then finally the case was settled with a compromise out of court. So after seeing the full picture of patent protection, let's now move on to trademark. Trademark and service mark. We generally know them under the big category of trademark, but trademark should be on goods and service mark should be on services. this is like a distinction, but then we can call both of them like trademark, and that's fine. So what is a trademark? A trademark is a word, could be a phrase, could be a symbol, could be a design, or any other indicator that show the origin of a good and the brand of a company. So also in this case, we have some legal processes to go through. So first of all, the right to trademark does not need to be registered. This is different from a patent. Having said this, in most cases, companies will register the trademark for many reasons. So one reason is that if you do not register this trademark, then you can't file any lawsuit against other companies that infringe your trademark. And second strong reason is that the registration of a trademark, then you can also use this at international level. So you can use it as an evidence that you already set up this trademark or service mark. Also in this case, we have some international treaties that help us with the registration of trademark, specifically the Madrid Agreement for international registration of marks and the Madrid Protocol. So these international treaties are treaties among countries that aim at the harmonization of rules and legislation to facilitate business among different countries. The third intellectual property right is copyright. So copyright is a protection which is granted to works of authorship. So basically any work created by intellectual ability of people. So a copyright does not need to be registered and give you the right to prohibit other people from reproducing your work or preparing some derivatives from your work, distributing copies of your work, or perform the work publicly, or displaying your work publicly. The work, however, should be tangible, so meaning that it should be clearly fixed, clearly structured, clearly documented. So for instance, a conversation or an impromptu speech, so these can't be copyrighted because they cannot be reproduced. They cannot be duplicated. An impromptu speech can't be duplicated. And additionally, we need to remember the doctrine of fair use. That means that in some cases, for example, if you want to criticize, or if you want to do like news reporting, or if you are teaching or researching, so in this case, you can utilize other people's work, and this does not fall under the copyright. In the United States, copyright for works that have been created after 1978 will last for all the author's life and additional 7 years. So this is the rule in the United States. Then again, for the copyright also, we have like different set of rules depending on the country. So which is what we have seen also for trademark and for patents. And also for copyrights, we do have some international treaties that help with the protection of copyright, specifically the Berne Convention that gives a minimum level of protection for copyrights, and again avoids discrimination of foreigners when they are filing for, well, in this case they don't actually need to file for copyright protection, so it avoids that foreigners be discriminated in a foreign country when it comes to their intellectual abilities and the result of their intellectual abilities. So what we have seen so far is like a legal protection for invention, for your trademark, so symbol, logos, and so on, and also for any form of authorship. But as you can see, so not everything will fall under these three categories. So companies do have a lot of processes, we do a lot of activities, but not all of them are innovations. Not all of them are worth a patent protection. Or not all of them are like symbol or designs that are worth to be protected through a trademark. So what other forms of protection can companies seek to avoid that their processes, their activities become public? And this is what we define as trade secrets. Trade secret is defined as information belonging to a business that are unknown to other businesses. And firms can protect this information. So this information, the trade secrets, will be protected even though firms do not file for a patent or they do not register a trademark. So how can we consider these trade secrets? How can we differentiate between what is a trade secret and what is not? So there are two main criteria. So a trade secret can be considered trade secret if they offer a distinctive advantage to the company in forms of economic rents. So here we have again the concept of a rent, of exploitation of an economic advantage. And the second criteria is that they remain valuable as long as these information are private, are not disclosed to the public. When this information are disclosed to the public, then there is no economic value any longer. So there are legislations protecting trade secrets. For example, in the United States, there is the Uniform Trade Secret Act. In the Uniform Trade Secrets Act states some additional requirements to be considered eligible for trade secret protection, which you can find here. So the information must not be generally known or ascertainable, easy to know, easy to presume. Again, we have this concept that the information must offer a distinctive advantage to the firm as long as they are secret. And trade secret holder must exercise reasonable measures to protect the secrecy, which means that you need to mark the documentation that include trade secrets. So you should mark this as like confidential, for example. This is to give an idea that you are serious about the trade secret. You also need to ensure that your data management system, your database, your server, and so on are sufficiently protected, because if you are not if you're not paying any effort to protect your information, then you do not deserve the law to protect you. And at the same time, you also need to ensure that your employees or your consultants or your lawyers are not disseminating this information. So you need to include, for example, in your employment agreements, a confidentiality clause that all your employees must keep this information secret. This is typical standard in employment agreements. When you work with consultants, you should always stipulate a non-disclosure agreement. When you work with business partners and you need to disclose some of this information, again, you should negotiate and stipulate with them a non-disclosure agreement. So all of these are some measures that can help you protect your trade secrets. And this will lead to the final topic, to the final theme of this video. So now that we know perfectly how can we protect our innovations, our trademarks, our authorship, our secrets in the company, so then there is a bigger question to ask. And the question is, should we always protect everything? Should we always file for a patent, register a trademark, and so on? Or in some circumstances, this does not make much sense from an economic perspective. So in some industry, legal protection is very effective. The pharmaceutical industry, legal protection is very effective. In other industry, it's not so much the case because it's easier to invent around or to do what we define as reverse engineering. So we start from the end product and then we do the reverse engineering to come up with the way to manufacture that product. So generally in electronic manufacturing, or generally speaking in manufacturing, filing for a patent is not so effective. It would be more important to actually keep a trade secret. In case in point, we can examine this IBM case. So this was back in the 80s when the PC industry was growing very rapidly. And so IBM was in a hurry to introduce a new PC. And they use many components that were not produced by IBM. For example, the microprocessors, they were from Intel, and the operating system was from Microsoft. But what IBM thought is, okay, we have our proprietary basic input-output system, BIOS, and this will be enough because this is patented, and this will be enough to avoid our competitors will copy our products. And they were also very confident on the aggressive legal team of IBM. However, what happened is that Compaq and other competitors were able to work their way around the patent. So instead of copy the code that was at the very foundation of the input-output system of IBM, so they just look at the result. So what was the result of this code? And then they move backwards, following like this reverse engineering process. And basically they were able to reverse engineer this without violating the patent. And so when this happened, all the other competitors just follow the same way, and there were like a lot of copies of IBM computers, copies that were perfectly legal because no one infringed the patent of IBM. So this is a case. This is a case where probably like filing for patents and try to get all this legal protection does not make much economic sense. But we have also other cases where the strategy could be completely opposite strategy. So this is the case when diffusing a technology is more valuable than protecting a technology. So this is especially when the learning curve effects and the network externalities can cause some industry to see this special phenomenon of increased rate of adoption. And when there are increased rate of adoption, we see that the more a technology is adopted, the more valuable this technology becomes. So if you are in this case, you actually want people to use your technology. You don't want to protect people. You don't want to exclude people from using your technology. So this is, for instance, the case of open source software. So software, of the code of this software is made available for others for augmentation, resale, and so on, freely. So in some circumstances, this could actually be a good strategy, but you need to keep in mind that once you give up on the control of a technology, then it's almost impossible to reclaim the control of this technology. And so then there is no way back. If you decide to open your technology to others, then there is no way back. And what is the implication of this? So the implication is that firms generally will try to find a way, will try to find a balance between fully proprietary system versus fully open system. So we can see this as a continuum, as a spectrum. So we have two opposite in the spectrum, fully proprietary and fully open. And then there are many degrees in between, many different shades of gray in between fully proprietary and fully open system. But let's give first a definition of a fully proprietary system. So a fully proprietary system is a system where goods are based on technology that is owned and vigorously protected through patents, copyrights, secrecy, and any other mechanism. Fully proprietary technology may be reproduced and augmented or updated by their developers only. So this is the definition. The definition of a fully open system is goods based on a technology that is not protected and that is freely available for production, for augmentation by anyone else in the industry. Then we have everything in between. So, for example, we have limited licensing. So, limited licensing is a combination of a strong proprietary system with some accessibility. Who generally utilizes this? It's a case of video games company. So video games company, they have a fully proprietary strategy for the console, but they implement a limited licensing policy for the games. So they encourage producers, developers to produce game in the system. But at the same time, they keep control, they retain control on the console. Then we have even a more open system. This is the open system of moderate licensing. So this system is probably like right in between, a perfect balance between a fully proprietary and a fully open system. The champion of this system, the moderate licensing system, is Microsoft Windows. So Windows is protected by copyright, and Windows protect the right to augment and upgrade the software. However, Windows can be installed in hardware. You can actually buy the so-called Wintel PC and laptop that consists of Intel microprocessor and Windows operating system. So basically, Windows give access to the software to all the original equipment manufacturers that bundle the software with the hardware. For example, Lenovo or any other PC and laptop company producer that combine Windows with their hardware. And on top of this, Windows also allows a complementary goods producer to create other additional services that can be plugged into Windows. However, the only thing that these companies can do is to augment Windows, so to upgrade Windows. And then the final one is the liberal licensing. So the liberal licensing is even more open access. So basically, you are granting access to the source code. This is the case of Java, and you allows commercial application, and they can also potentially augment the source code. So, and finally, we will reach the most open system, which is the fully open system. So when should we go more towards the protection? Where should we go more towards the diffusion? So, well, there is no a single answer. There is no one size fits all. So we need to see based on the industry, trends, dynamics, and so on. But we can see what are like the advantages of each system. So the advantages of a fully proprietary system is rent appropriability. So if your purpose or if your industry dynamics allow for rent appropriability, so a proprietary system would be the way to go. Consider that if you have this rent position, then you can invest further in development of a technology, augmentation, promotion, and also to enhance your distribution network. And finally, you have a firm control on the evolution of a technology and complementary goods. So gives you to an extent a very prominent position to guide the development of a technology. However, there are also advantages of a diffusion. So the advantages of a diffusion is that you can have a very much faster adoption. So again, here you can reach install base and also add the complements, and we know that all of these can increase the value of a technology. At the same time, you can pool ideas, resources from other firms, and this can improve the level of technology, even though you need to keep in mind that then this can also lead to conflicting interpretation of a technology. So the problem, the Achilles heel of open system is possible conflicts among different developments of a technology. Final point to consider is your firm's internal capabilities. So especially manufacturing, production capabilities, marketing capabilities, and finally capital availability. So these factors will influence the benefits of protection versus diffusion. So here there is a list of questions which you can use to analyze whether you should go for more protection or you should go for more diffusion. So the first one is whether you can produce the technology at a sufficient volume or a sufficient quality. So this was, for example, the case of JVC when they introduced the video cassette, the VHS standard. So they were really aware that they didn't have manufacturing capabilities to win this competition. So what they did was to open to other firms to be the OEMs, the original equipment manufacturers, and to produce VHS on their behalf. And this was a winning move because then VHS became the new standard in the industry. So this is a case of a company that understood what was the weak point, and then they decided to go for more diffusion to help the VHS to become the standard in the industry. Another factor to consider is complements, the role of complements, the availability of complements in terms of quantity and quality, whether you can produce some complementary goods or whether you need other companies to produce complementary goods. One more factor is whether there is some opposition in the industry to avoid whether there is only one source of technology. You also need to consider if you're able to improve the technology and to move ahead with a new level, a new upgrade of a technology fast enough before your competitors, or if you don't have these capabilities in your organization. You also need to consider whether it's very important for your technology to prevent the technology to be modified, or whether it's very important that in your industry there is one single harmonized standard. And the final point is whether you would have to have some architectural control in the technology. So in some cases, for example, like the case of Microsoft, they reached this architectural position because they became the standard in the industry. And if you reach this position, then it's almost like a monopoly. And you don't actually need any patent or other legal protection because you already reached this monopolistic position in the industry, which is enough for you to reap the benefits out of your position. Benefits that are not only related to the exploitation of market potential of innovation, but also the direction that you give to the technology. And this leads to a point which we discussed in some prior videos of a path dependency, that even minor events can change the trajectory of a technology, the development of a technology. And if you are in an architectural position, then you can to an extent guide this path dependency and guide the next development of a technology. So to conclude, what we analyzed today first was the legal remedies, the legal protection to innovation. So we have seen that invention can be protected through patents, which give this rent exploitation for up to 20 years, provided that the invention complies with patent requirements. We have seen also some other intellectual property rights. We've seen trademarks, we have seen copyright, and we have seen trade secrets. But after this overview and analysis of legal options to protect innovations, we came to wonder and discuss when and if we should protect innovation. And this is the dichotomy between fully proprietary technology system versus fully open technology system, and all the different options, all the different shades of gray in between, which depends on the industry, which depends on the market, which depends on the technology, but also on the capability, the ordinary and dynamic capability of an organization. I hope you enjoyed the video, and I look forward to see you in the next video. Thank you. Bye.